Divorce. The internet has spoken, and divorce is the topic for today. What are the stages of a divorce? I really had a multi-part question, and it was about the stages and timelines and factors from beginning to end. So let me give a summary proceeding on divorce. A divorce is commenced by a plaintiff. The plaintiff is the one that pushes the divorce, right? Push. And the person that receives it, so that's done by a summons with notice or a summons and complaint. The summons and notice, getting ahead of myself. Hello, you're being sued for divorce. Summons and complaint. You're being sued for a divorce, and this is the reason why, in full explanation. The person that replies to a divorce is called a defendant. They defend, like football, defensive. I guess in baseball, you can have defensive, right? The defensive team is the one that's pitching, right? So your defenders are your infielders and outfielder and the catcher. And even the pitcher, if the ball's hit right to him or her, if we're speaking softball, although my reference was baseball. D is for defending, plaintiff versus defendant, and the document that the defendant puts in is either a notice of appearance, hey, I'm here and I'm involved in the matter, let's speak about this further, let's negotiate, or an actual document called an answer. Amazing how we come up with this in the law. The answer to the complaint is a document called an answer. Timeframes. After someone's complaint is filed, the person has 20 days to reply. If there's any counterclaims, the plaintiff can respond to those. And then there's going to be some negotiation, some discussion, some conversation, or at least there should be. Maybe an offer by letter or a telephone call or some kind of communication and conversation about this is what the parties have, this is how I propose we split it up, and depending on how complicated it is, and how agreeable the parties are, that dictates how the case is going to go. Now, if there's that offer made, or even if there's no offer, but there's no conversation, no communication, people at this, right, whatever this is, banging our heads against each other. If there is no agreement, someone, plaintiff or defendant, has to ask for a preliminary conference that says, let's get in front of a judge, let's get a judge assigned to the case, let's have more and further discussion. It's either more or for the first time conversation, and let's discuss it. And then ultimately that goes all the way to a divorce. Preliminary conference, compliance conference, several compliance conferences, perhaps discovery, litigation documents back and forth, all the way to a pretrial conference, and then ultimately or a settlement. Resolution by written agreement can happen as well. We always push for settlement. I'm sure many other attorneys as well. We prepare for trial and we try to settle. Preparation always, trial if necessary, and settlement preferred because you intelligently, specifically say what you can take, can accept, what you can give up. That's why we try and settle. I think that's it for now. Thank you.